Motion, my lord.
Fresh.
He's a doctor, my lord. His license has been, my lord,
Fresh matter.
Fresh matter.
Monday.
Wait, please, Your Lordship, my lord. My lord, item number 15, my lord. We have some personal difficulties today, my lord.
You are for the petitioner.
My lord.
Item 15 on the request made by the council to the petitioner stands deferred. Stayed after 2 weeks.
Obliged.
May I please, your lordship? My lord, in item number 40, lordship, we need further 1 week time to complete our instruction, lordship. I have already taken the consent from the other side, lordship. Lordship, can it be taken up of lordship
40.
1140, lordship?
You are appearing for?
Guwahati High Court, lordship. Decision.
Who's for the petition?
for the one date may be fixed.
How much time you are asking?
1 week, lordship. Only one.
Council for the appearing for the registry of the Guwahati High Court. Praise for further 1 week. Complete instructions. Stop prayer made is not objected to. List this matter again on 8th of December.
Lordship.
8th of December.
Deeply obliged.
My please, Your Lordship. My lord, I beg permission for listing of a fresh matter on Monday, Lordship.
Fresh motion,
Fresh motion, Lordship. Obliged.
subject to clearance of defects.
I look.
May I please, your lordship, pray for listing 4 writ petitions for listing for admission. The matters pertain to non-payment of pension.
Payment of pension, let it come in January. 7 January.
And also, I pray for listing of 2 arbitration petitions.
Arbitration will be listed any day. You go and take it up with the registry.
But they asked me to mention in the court, madam.
Monday? Yes.
Lordship, but I beg to mention for a listing of an writ petition, Lordship. We have filed an IA in this writ petition for rectification of some type of graphical error, Lordship. Lordship, Tuesday or Wednesday, Lordship?
10th,
Then-
Wednesday.
Wednesday.
Wednesday means you want it on 3rd.
Third, yes,
All
Lordship.
right, 3rd.
May I
Yeah,
please, your lordship, with the consent of other side, I beg to mention item number 6.
6.
Yes,
Okay, item 6 on the request made by the council for APDCL.
yes, APDC.
Matter stands deferred to be listed after 2 weeks. It is submitted.
Lordship, I am
Consent
for the
of
petition.
council for the-
Lordship, I am for the petitioner, kindly fix it there before
Right.
vacation.
Before vacation, not possible. Let it come in January. 7th of January. Council
May I
for
please-
petitioner, yes. There's no.
May I please, your lordship?
List on 7th, yes.
Wait, please, your lordship, I beg to mention listing for date petition for Monday.
What is the subject matter? For what purpose?
Disciplinary and inquiry proceedings for this.
Disciplinary and inquiry proceedings. Let it be on 8th of December. 8th.
8 December.
May I please, your lordship? My lord, I beg to mention a fresh matter for listing on Monday, my lord. It's a matter.
Fresh matter, when did you file it?
My lord, it was filed 4 days ago, my lord.
Why are you hiding behind a mask?
I am unwell, my lord.
All right. Let us at least see your face. Yes.
My lord, can it be fixed on Monday, my lord?
Fresh matter.
Yes, my lord, it is.
All right. Subject to clearance of defects. Yes.
May I please, your
Obliged.
lordship. Lordship, I beg to mention for listing on 5th of December, lordship.
What matter?
Lordship, the matter is related to removal of Gaon Panchayat ward member, my lord.
Gaon Panchayat ward member.
Yes, removal, my lord. Notice has already been issued, but there is no interim, lordship.
When is it returnable?
After 6 weeks, which is already over, my lord.
Then let it come on 8th.
8. Obliged, lordship.
May I please? So I beg to mention for listing, my lord, admission matter, my lord, any date before vacation, my lord.
Let it be after vacation. What is the matter? Subject matter?
Matter relating to the, my lord, service of, my lord, gardener, my lord. Gardener.
Gardener.
Any date, my lord?
10th of December.
Master class.
Please, your lordship, I beg to mention for listing of a writ petition for motion, lordship. On Monday, lordship, if it is possible.
Fresh matter.
Fresh matter, lordship. I filed it on 24th, lordship.
All right.
That's it. Obliged.
Yes.
May I please, your lordship, my lord? My lord, I beg to pray, my lord, for admission hearing, my lord, to be accommodated, my lord, on next Thursday, my lord, because the facts, the matter relates to why.
Which item? Which item?
No, my lord.
Not
Mention,
listed.
my lord, mention, to be accommodated on the Thursday, my lord.
What is the matter?
Matter relates, my lord, the wife claims the pension and gratuity of her deceased husband, my lord. I'm already in the interim, my lord.
We can give you a date on January. Take a date in January.
My already returnable date is over, my
Let it be on 8th of January, reopening. 8th
8th of December.
January, Thursday.
Then, my lord, I'll pursue the department itself, my lord.
Huh?
Through the department, my lord,
In person.
I'll pursue. With all respect.
May I please your lordship, item number 17, example for the day, lordship.
Item
17.
17. Item 17 passed over to be listed on Monday. Yes.
Page 19 and 20. May it please, your lordship. By page 19,
We'll issue notice.
my lord.
Mr. P.K. Roach was there. Issue notice. Returnable after 4 weeks, steps on the respondents by registered post AD within 1 week from today. Based after returnable date.
May I please, your lordship. Well, direction was issued to finalize the pension and pensionary benefits, lordship.
Same order, heard so and so, issue notice. Returnable 4 weeks, steps by the registered post within 1 week from today.
Fine.
Based after return.
Obliged.
Wait, please, lordship. Discuss lordship the matter relating to Anganwadi welfare, lordship. Lordship, advertisement issued in the year 2024, lordship. And accordingly, the petitioner applied on the post of Anganwadi helper, lordship. Subsequently, the responding authority issued a select list for the interview, lordship. Annexure 5, lordship, page number 20, lordship.
Yeah, what instructions have you got?
Lordship, till now, we have not received any instruction. So, may some more time may be given.
Why so much of time is necessary just
We-
for this instruction?
We have sent our,
22/9 notice was issued.
we have sent our letter, but till now not received any instruction.
Also, the respondent number 5 already rejected, lordship, and subsequently, there is no supplementary list, lordship, but she has.
You are
allowed to-
asking for cancellation of the appointment of respondent 5.
Lordship, no. For selection, lordship. Appointment letter has been issued, lordship.
No, so
The process is
respondent
going-
number 5 is appointed,
No, lordship,
not
but
appointed,
she applied, allowed for interview, lordship.
allowed for interview.
Lordship.
You are
Even
not
though,
allowed for,
even though her name was rejected in the,
are you allowed for interview? No,
I am allowed, lordship,
you are allowed.
lordship,
So you are allowed, respondent 5 is also allowed.
allowed.
Who is selected now?
Lordship, nobody has been selected, lordship.
Then why are you agreeing?
Lordship, the respondent number already rejected, lordship. His candidates are already rejected, but she,
Supposing you are selected, then how are you agreed by respondent 5? Assuming she was rejected, she was allowed to appear. After appearance, you are selected. How are you agreed?
he may be selected,
Your
lordship.
grievance comes only when respondent 5 is appointed. It is premature.
No, lordship. Already after verification of the document, lordship, the respondent also prepared the list for the valid candidate and the rejected candidate, lordship. Already she has been rejected,
She is rejected, she is called for interview.
lordship.
You are not rejected, you are also called for interview.
Lordship.
Now, out of this interview, who is selected?
Nobody selected, lordship. The process is going on, lordship.
Then it is the process of selection that you are affected by. We close it. We give you liberty to come back.
Lordship, she may be
Where is your
appointed,
grievance?
even though
I
she has
don't
been
understand. What is your
rejected.
grievance? What is your grievance? How are you affected by the lady being allowed to appear when the process of selection is still
Lordship,
underway?
kindly see the page number 34, lordship, the reject list, page, annexure 6, lordship. Lordship.
No, we are not going into academics. Why should we ask them to get information whether she was allowed to appear, not allowed to appear? You are also allowed to appear. Selection is not complete.
No, lordship.
Then How, what is your grievance? Your prayer is to direct them to appoint you. Cancel the candidature. Why? She may not be selected. You may be selected. It is only when she is selected, then these, your grievance, it will give rise to a grievance.
Well, definitely the respondent authority.
Right, counsel for parties, this writ petition is filed by the petitioner who is assailed. The call letter issued to the respondent number 5 for selection appointment, which is being undertaken as a part of the recruitment process for appointment of Anganwadi helper at Satkura Digirpar LP Anganwadi Center. According to the petitioner, 6 candidates applied, and out of the 6, 2 were found to be eligible and 4 were rejected. Stop. However, one of the rejected candidates, namely respondent number 5, has again been called for an interview by the authorities. Stop. The process of selection by way of interview is underway and no final results have been declared. Stop. Petitioner is aggrieved by the fact that respondent 5, whose name appeared in the list of rejected candidates, was called by the respondents. Stop. It is, however, not disputed by the counsel for the petitioner that the petitioner has also been called for and has appeared in the interview. Under such circumstances, the present writ petitioner is before the court. By earlier order dated 22/9/2025, this court directed the respondents to obtain instructions. But when the matter is called up to the instructions, further time is prayed for the respondent counsel. This court is of the view that at this stage, the grievance of the petitioner is premature. The prayer made in the writ petition is seeking a direction to the respondent authorities to select the petitioner as Anganwadi helper of Satkura Digirpar LP Anganwadi Center and to issue necessary appointment orders and a further direction to cancel the candidature of respondent. This prayer at this stage, according to this court, is premature as the results of the interview in respect of the selection process has not yet been completed. So the grievance of the petitioner, if any, will arise only when the petitioner is rejected and some candidate, including the private respondent number 5, is selected. This situation has not yet arisen. So the respondents have also submitted that the interview process is not complete. Not complete.
Interview is completed.
Complete.
Complete. Results.
Instruction.
And the results have not yet been declared. Under such circumstances, this court is not inclined to entertain the present proceedings in the present form. The petition stands dismissed as it is premature. However, liberty is granted to the petitioner to approach this court if his grievance still persists, pursuant to the results being declared by the respondent authorities towards selection of Anganwadi helper, the influence of Anganwadi center. Yes, post.
Please, your lordship. So this is pertaining to non-payment of family pension to the wife of the deceased employee.
Yes.
Yes,
Any
last occasion
nominee?
Lordship directed us to who has maintained the service book and as well as nominee. Now I have received one communication from the department, Lordship. Then may I please? Copy tomorrow night.
Accountant General,
Lordship.
you
Yes.
see this, you are maintaining the service books.
Lordship, kindly peruse page 25, Your Lordship. RTR reply.
But one copy of the service book will always be available.
Lordship, it should be with the department, Your Lordship. We are not maintaining.
But this is a letter from department head.
Kindly peruse page number 25, Your Lordship. Annexure read.
He is an employee of Health Department.
Health
Well,
department.
department, yes, Lordship.
When
But
did
in gazette,
superannuate-
in
when did the
gazetted officers, including doctors, maintained by accountant general. Otherwise, I have talked to one joint director. He has also said that, yes, maintained by accountant general.
And which letter you are referring to?
Our reply to the RTA application filed by the petitioner, Your Lordship.
However, we have prayed for
in-
furnishing these
In
documents.
page number 25, please. May I read, Your Lordship? Inviting reference to your RTA application dated 17/2/25 received in this office. And so I am to state that the service book is not maintained by this office, and last pay certificate is issued by the concerned BDO. Furthermore, the demise so has not been intimated
To
to
this
this office. Hence, the office is not in a position to provide the service book.
He has not intimated, Lordship.
Who has not intimated?
Petitioner has not.
No, my lord, the
has not
office was not
intimated.
intimated regarding the death of the
And
husband of the petitioner.
And another one aspect is, Lordship, that one's title suit is filed against the deceased and the wife regarding the validity of marriage in the
Where is it?
Itabor.
Where are the particulars?
No, that's a totally
No, but
different issue.
Title suit being filed between deceased and the petitioner
Yes.
No. The brother of the deceased
and the petitioner.
and the definitely and the petitioner challenging their validity of marriage. That is still pending.
My lord,
That is a different issue.
that
but
is a different
We
issue.
wanted to see whose names are there in the nominee, the service book or
Now department has written this
where,
letter.
what, did he superannuate from service?
No. During service, he died.
Died in France.
No, but one set of copy has to be available with the, you check up with your Health and Family Welfare Department.
It will liquid is small.
But
It will liquid is one soul.
Pay and leave salary was issued by, my lord, the office of the principal accountant general, my lord. Enclosed, my lord, the last pay slip one. 7. And my lord,
You get
next,
your instructions from your accountant general.
Lordship, I can get, but the service book is maintained by the concerned department.
You know, but there is a very categorical
Lordship, I can
instruction.
obtain instruction, Your
You
Lordship.
get it?
Lordship, I may
Do you
be
have a
provided.
copy of the instruction?
Yes, Lordship.
Please furnish it to him.
also a copy may be directed to punishment to me. Copy of the same may be furnished to me, my lord.
Can you furnish a copy?
No, I'll furnish. Lordship. Copy need to photo will
Pursuant to the last order, the Standing Council Health, it has placed before the court a communication issued by the Joint Secretary to the Government of Assam, Health and Family Welfare Department, that the service books of gazetted officers, including doctors, are maintained by the Office of the Accountant General Assam.
Lordship, my submission may also be recorded.
Stop. This submission, however, is countered by the Standing Council Accountant General, who submits that service books are not maintained by the Accountant General. He has referred to the reply given in the RTI to the rate petitioner, which is enclosed as Annexure 8, page 25.
17,325.
So be that as it may, we permit the respondent, both the Standing Council Health to complete their instructions and apprise the court within 1 week from today.
The date may be fixed, my lord.
List again on
12 Lordship.
12th already.
All right.
12th of December.
Like that. It is my
Yes.
So I filed my reply yesterday. my lord.
The Standing Council of the bank submits that a reply counter affidavit
Lordship.
has been filed yesterday. Of the same is not available in the case report. Please this matter again.
Lordship, I will file a reply to that, my lord. That's all. And notice has not been issued, my lord, in this case. Lordship may issue a short notice also.
Notice is not issued,
No, my lord. It may come up for admission then.
but since the reply has been filed as stated by the council for the respondent bank, that notice issue returnable on 9th of January.
But can it be before the vacation? There's a stay on the transfer. my lord.
We help here to issue notice. You have already filed, but
Yes.
uh,
Perhaps my lord, formal notice now is not relevant, my lord, because I already filed and they are praying for time to file rejoinder. That view of the matter, my lord, is perhaps a short, because ultimately, my lord, there is a stay.
12th of December.
Lordship.
The petitioners are permitted to file their reply. Interim order passed earlier, we will continue in the next next.
All right.
7.
Application, Lordship, kindly may allow for timing, Lordship.
Huh?
Kindly may allow for timing. My senior Legon in court number, Lordship, 15, Lordship.
Instruction is there, Lordship.
What
In fact, so new Lordship inquiry officer has been appointed, Lordship, in this case. The earlier incumbent Lordship died, Lordship.
Let it come, we'll take it up after a while.
Lordship.
Yes.
8.
My pleasure, Lordship. My lord, on the last occasion, it was directed to take the instruction, my lord.
Lordship, I have received instruction, Lordship, but it's not as I say, like a parawise comments, Lordship. But the main thing is that this whatever is the meeting, Lordship, which is in page 94, Lordship, Annexure 10. This the management has been asked to address the issues, Lordship. So it is the employer, Lordship, and the management who has to look after all these things, Lord.
Who is the employer?
The NHM, and I think they are under some GVK or something like this, Lordship.
But my lord, it's for long, and
This is their Lordship.
they are the answerable, my lord.
Huh?
As per my lord, labor contract regulation, the employer, my lord, responsibility of the wages, it lies with the principal employer. Lordship.
Yes,
Lordship,
but
can
labor
have a
petitioner
look-
is not the employer, Lordship.
We'll issue notice here.
Yes,
Lordship.
Lordship.
Third council for parties.
Notice of-
3 weeks. MS M Bhattacharya is here for respondent number
Only 4, Lordship, I am representing.
4.
Yes.
Another, my lord, all the council represented would have served their name and been sealed.
MS S Borua appears for respondent 1. A Bora for number 2, 3, 5 and 6.
Private.
You are appearing.
No.
Lordship, they are actually the home, under whom actually the service have been operating, Lordship. They are the main.
NRH.
Oh, you know nothing.
Very simply.
The respondents 1, 2, 3, and 4 are represented. So the way the extra copy will be furnished to the utility 1 week from today. Steps on respondent 5 and 6 by raised to post AD within 1 week from today.
Lord, there is an interim prayer also, my lord.
Focus on the interim prayer list again
These are against respondent number 4 and 5, Lordship.
on 19th January.
Lordship.
Deeply obliged, Lordship.
May I approve?
Suction.
Yes.
Yes, I have instruction. Subsequent development has come. Subsequent development.
Subsequent development.
That is.
You're challenging, what are you challenging?
Lordship, I have already joined my new place of posting, Lordship. On 6/11/2025, I have been transferred. On 7/11/2025, I have joined my new place of posting. But-
Which is? Where is
Which
the
is
transfer order?
transfer order, Lordship, at page 13, Lordship.
So you are transferred in Koraghat.
Lordship. And the respondent number 5, Lordship, he is attached to Koraghat ranch.
What is the meaning of this, Mr.
Lordship,
Standing Counsel?
Lordship,
Now new transfer order is issued.
Not issued.
Lordship, on 15/11, private respondent number 5,
Uh,
the respondent number 5, remains state.
Huh?
Yes, deputy ranger inserts, my lord, in the last paragraph, Sahanur Alam Sheikh. This is the respondent number 5, Lordship.
No, what is the meaning of remain state?
Under stay.
Hereby stay means?
Stay means. Yes, inserts in the same place of posting.
Huh?
May, Lordship, it is.
Same place means which place? Koraghat.
Koraghat.
What will happen to the petitioner?
And he is a deputy ranger, Lordship. He is not entitled to hold the particular search, Lordship, of the particular range.
So now a new order has been
on 18/11.
Lordship, may I place one office memorandum, Lordship?
There is a new order. You have to put it under challenge.
That is a proposal, Lordship.
What proposal? There is an order already issued on 18/11.
Proposal for transfer, Lordship.
Now you are
Given to us.
already reply.
Proposal.
Proposal, Lordship.
Earlier,
Lordship, may kindly. have a look.
earlier place of posting, my lord. Koraghat range. Now. Reply, no?
What is this?
Lordship, this office memorandum says, Lordship, after the transfer order, they need to comply. Only after, Lordship, compliance of the transfer order, they can ventilate their grievances either in the judicial forum or administratively. In the administration. And our notification has not been cancelled or modified, Lordship. That is still in force. And it was issued on 6/11. And I have already relieved from the earlier place of posting, Lordship, and I have joined my new place of posting on 7/11. Joining report, Lordship, may kindly see at page 14. And he is only a deputy ranger. I am a ranger. The deputy ranger is not entitled to hold the particular range, Lordship. And Lordship, this honorable court has
But
repeatedly.
as on date, the order has not been issued.
Not
Lordship,
issued.
this much
Notified
only I
order has not been
received
issued.
instruction, Lordship. Other detailed instruction may be required, Lordship.
Then we'll issue notice here.
Notice may be issued, Lordship.
Third learned counsel for parties to notice return to 2 weeks. 3 weeks. Mr.
DC Musahari,
C. Musari.
DC Musahari.
B.C. Musari appears for respondents. 1, 2, 3, 4, all of them. 1, 2, 3, 4.
1, 2, 3, 4.
1, 2, 3, 4. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Steps on respondent 5 by registered post, speed post within 1 week from today. Pursuant to the earlier order, dated 24/11/2025, whereby the standing council was permitted to obtain instructions. The standing council has placed before the court a proposal which has been mooted for modification of the earlier transfer order by proposing to transfer the petitioner to Dipli range under Porbot Jora division. Parika. However, no specific transfer order has been issued as on date. The counsel for the petitioner, on the other end, has placed before the court an office memorandum dated 25/11/2024 to submit that in terms of this memorandum issued by the Personnel Department, Government of Assam, officials under order of transfer need not wait for release order to hand over charge once an order of transfer is issued. If an official does not hand over charge on his own promptly, the official shall stand released automatically. So, in that view of the matter, the matter be listed again on 7th of January.
Lordship, may kindly give an observation, Lordship, the pendency may not be a bar to give the unilateral charge.
On which date the respondents will apprise as to why the OM dated 25/11/2024 shall not be applicable in the case of the private respondents. The pendency of the writ petition, however, shall not be a bar. Or
To
what?
give unilateral charge to the petitioner. Lordship.
To allow the writ petitioner to assume unilateral charge in terms of the memorandum dated so and so.
That's all right.
Deeply obliged.
Like-
Obliged.
7 January 26.
Item 10.
May it please the Lordship. My lord, the petitioner here is, he is retired from service on 31/7/2024. And my lord, I have not been paid the regular pension. I have just paid the provisional pension, and the reason is, my lord, due to pendency of the disciplinary
Notice.
my lord.
Council with the notice. Returnable 4 weeks. MS Neo appears on behalf of respondent 1 and 2. And MS Mr. R.K. Talukdar appears on behalf of respondent number 3. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 month. Matter be listed after the returnable date.
My lord, may I prefer date, my lord, because matter is covered by judgment. I will impose this matter at page 58. Similarly, placed persons have been relief matter. The date may kindly be fixed, my lord, after 4 weeks.
List on 7th
My
January.
lord, deeply authorized, not.
11.
May I please, Your Lordship? Here the petitioner is aggrieved by the order dated 23. Where is it?
Agreed by?
Madam. Here the petitioner applied for the Anganwadi helper, my lord, where the private respondent number 7 and the petitioner belongs to same village. And here there is a notification that is page number 16. 23rd September 2022. There clearly stated that the selection procedure, how to conduct the interview. That is page number 18. That clause 2(1). The petitioner is a widow, my lord. The petitioner is a widow, my lord. Here it is said, may I read, my lord? Selection of candidate for the post of Anganwadi worker and the worker in mini Anganwadi center shall be made strictly on the basis of marks obtained in SS examination, and the selection of the candidate for Anganwadi helper shall be made strictly on the marks obtained in the HSLC examination. However, in case of the candidates is widow, divorce, above 40 years unmarried woman, daughter or daughters-in-law of Anganwadi worker who died while in service shall be given additional 10 marks to be added with her percentage of the marks obtained in SSI. Here the petitioner is the HSLC pass, my lord, and she is only the widow candidate, my lord. They have not followed the selection procedure. Despite that, they have appointed the private respondent number 7.
No, widow.
They have to prepare 10 additional marks.
What is the meaning of who died while in service?
A person above the age of 40 or died in service, mean, my lord. Suppose there's a mother-in-law who was working in the Anganwadi helper, and the daughter-in-law.
But if you read the sentence, it is applicable to all widow, divorcee, above 40 years, daughter-in-law.
Yes, my lord. I am in this category, my lord. I am the widow.
So you are the widow.
Yes, my lord.
Reading the sentence, it will mean that your husband expired during service. Was he employed in the Anganwadi center?
No, my lord. However, in case of candidate is widow, divorce, above 40 years of unmarried woman, daughter or daughter-in-law of the Anganwadi worker
who
died while in service shall be given additional 10 marks. Meaning thereby, my lord, I am a widow candidate, my lord, and they responded number.
You're a widow,
my lord,
and your husband worked as an Anganwadi worker, therefore you are given 10 marks. That is how I'll understand it.
By my understanding, it's not. It's like, my lord, and widow is widow.
Lordship, approaching before this honorable court, almost after the whole process completed, whole the entire exercise has already come.
Appointment made, Lords.
And also, and
Who is the
nothing
person appointed?
the private respondent number 7, my lord.
Then we'll have to issue notice.
My lord. In this, my lord.
Heard learned counsel for parties issue notice returnable 4 weeks. Mr. BC, but
BC Musahari.
BC. Appears for respondent number.
Lordship, I'm for respondent number
456.
4-5
456.
Lordship.
MS. Who's appearing for women and child?
M. Kalita.
M. Kalita for respondent 1.
1, 2.
2. And Mr. Nayak for respondent number 3. Stop notices on respondent 1 to 6 are waived as they're represented by respective counsel. Stop steps on respondent number 7 by speed post within 1 week from today. List this matter after the returnable date. Extra copies be furnished to the standing councils.
Item number 18 also similar case. Here 18, my
Item
lord.
18.
18, yes, my lord.
Right. Similar. Issue notice. Huh?
Kindly see here the marks obtained by the petitioner as well as the private
Well,
respondent.
item 18, there is a caveat.
Caveat, yes, my lord.
My lord, I am appearing on behalf of my lord, caveat.
Oh, okay. Third, counsel for the caveat discharged in item 18. Otherwise, same order. We are only issuing notice.
Notice.
Then item 18 or file person. You don't need. Here I have 1 to 6 represented by the department counsel, 7 by Mr. Sanjay appearing there. The counsel so and so will file the caveat on behalf of respondent 7. No steps by speed post to be required. Yes.
Oh, my lord, since the caveat is there, my lord, I can serve.
We have already recorded. Yes.
Oblate, my lord.
My lord, the petitioner, my lord, there is a dismissal from service, my lord. My order dated, my lord, 22nd/3/2025, my lord. According, my lord, he filed, my lord, appeal, my lord. Lord, petitioner pray, my lord, to dispose the appeal by the respondent, my lord. He appeal file, my lord, 11/4, my lord, 2010. That is, my lord, next up 15, my lord, page 1.
Appeal not disposed of.
Yes, my lord.
Mr. Nayak,
Lordship, here the penalty imposed was dismissal from service, Lordship. In that situation, Lordship, Governor is the appellate authority. If Lordship comes to page 105, Lordship.
he was appointed as what?
He is accounts officer.
Accounts
He was
officer.
accounts officer.
So it was addressed to the principal secretary to the government of Assam. And it was through registered post, Lordship. I'm not sure whether this was received in the department or not. But and Lordship, an appropriate appeal was preferred on, it was received on 14/8/2025, Lordship. And it was to the governor, Lordship. Page 108. But Lordship, for so far as limitation period is concerned, Lordship, that is 3 months. So his dismissal from service was in the month of March, Lordship, and the proper appeal was filed in the month of August, Lordship. So that is after 3 months.
You get instructions.
Lordship.
Your only prayer is for a disposal of the appeal.
Disposal of the appeal, Lordship. So I have not taken any instruction till now, Lordship.
Take
So
instruction.
Lordship will issue notice,
Take instruction.
Lordship.
But counsel for parties. Petitioner is agreed that the departmental appeal filed by the petitioner against the order of dismissal issued by the disciplinary authority under the Assam Discipline and Appeal Rules 1964.
Condemnation or
Disposed of
department
Mr. Additional AG appearing before state
appeal to any other provision
is permitted to obtain instructions with regard
June
to
appellate
status of
authority.
Appeal 5.
address for
List again on
9th
9th of January. 9th of January.
Correspondent number 3, Your Lordship.
Mr. R. Boro appeals for respondent.
I am appearing for 1, 2, and 4 only, Lords.
I have to appeals for 1, 2,
1, 2, and 4.
1, 2, and 4.
May I please? The petitioner number 1 is the second wife of deceased, and the number 2 is the daughter of from the first wife. Let's say in 1996, the first wife separated and she was living separately. Then I made my marriage was solemnized in 1997. Since then, I'm living with the petitioner, the deceased husband. Lordship. He retired in 31st of January 2018 and died in 11/9/2025. Lordship. Now, Lordship, my first wife, she is surreptitiously obtained death certificate and applied for the pension. Lordship. Lordship, Annexure 1 by Annexure 1, POP is issued in favor of first wife. Lordship.
Annexure 1 is the PPO, Lordship.
PPA is
Not in
issued in favor of the petitioner. Lord. In the favor of the petitioner.
Have you
This
released
is
the
as well.
pension?
Lordship, it is till date it has not been released. Lordship.
Not yet.
Not released, Your Lordship.
Heard Mr. SCPL, counsel for the petitioner. The petitioner is aggrieved.
Lordship, kindly peruse page number 23, Your Lordship.
So petitioner one is who?
Petitioner one is a second wife, Lordship.
Second wife, and two?
Two is a daughter from the first wife, Lordship. She's living with me since 1997, that's 1996.
See the age you have given?
Lordship.
Difference between the age is 11 years.
Lordship is the first wife, Lordship.
Second, his daughter is 34 years.
Yes,
Mother-
Lordship. She's from the first wife, Lordship.
So she's from the first wife.
Lordship.
Oh,
1996, Lordship.
Right.
Lordship, PPO
The writ petitioner number one is the second wife of one late Champok Kumar Talukdar. Stop. Writ petitioner number two is the daughter of late Champok Kumar Talukdar out of the marriage with his first wife, who is arraigned as respondent number 6 in the present writ petition. So the writ petitioners submit that the marriage of late Champok Kumar Talukdar with the respondent number 6 was dissolved. When was it dissolved?
It was not dissolved, Lordship.
Huh?
It was not dissolved, Lordship. She abandoned the Jindal Kumar, husband of the second husband in 1996.
Lordship, in pension paper, Your Lordship, second wife name is mentioned as nominee.
Yes, Lordship, it is there. It is not mentioned, Lordship. We have made a
And I
statement
think
to that
Lordship,
effect.
PPO is issued in favor of the deceased. And thereafter, after demises of the deceased, Your Lordship, Treasury officer forwarded, returned the pension paper to us, Your Lordship.
You write the first wife. The marriage between the petitioners, marriage between late Champok Kumar Talukdar and respondent 6 fell apart, and respondent 6 started living separately with the first daughter, which is petitioner number 2. Stop. Petitioner, the late Champok Kumar Talukdar thereafter entered into a second social marriage with petitioner number 1. Thereafter, petitioner 1 and late Champok Talukdar lived together as husband and wife. The petitioner number 2 is also raised by the petitioner number 1 and late Champok Kumar Talukdar. So the Champok Kumar Talukdar, however, expired on, when did he expire?
Lordship, he expired on 12/9/2025.
12/9,
Lordship, sorry, I'm sorry, 21/9/2025.
21/9/2025. Stop. It is submitted that in the service book, in the papers available with the department, the name of petitioner second wife was nominated.
Yes, first wife.
First wife was nominated.
First,
Your Lordship.
first wife name is there.
Lordship, may kindly peruse page number 20, Your Lordship.
The name of the.
In the
first
event
wife
death
is
of
there.
pensioner, family pension of the following rate may be paid to the Srimati Junu Talukdar, Your Lordship. She is the second wife, first wife, Your Lordship, sorry.
In the particulars which are available with the department, the name of the first wife is mentioned in the event of death of the pensioner, namely Champok Kumar Talukar. Stop. Petitioner expired on 29/2025. Stop. Subsequently, the private respondent number 6 has approached the department, and thereafter the family pension has been issued to the
Family pension not issued, your lordship.
not issued.
Not issued, your lordship. Lordship, pension, PPO was issued in favor of the deceased, lordship. Thereafter, it was after demises of the deceased, your lordship, Treasury returned the PPO to office of DIG, your lordship. Lordship may find
Page
in
23.
page 23, your lordship.
After the demise of the late Champok Kumar Talukar, the Treasury New Guwahati Treasury Guwahati has returned 4/2 of the PPO and the death certificate along with the application to the Accountant General. Stop. This is on the basis of the application filed by the respondent number 6. Stop. The petitioners thereafter, one being aware that the department is likely to include the name of the respondent number 6 towards grant of family pension, has filed an application before the authorities on 21/11/2025. So since no response is forthcoming, the present petition is in file. Having heard learned counsel for parties, we should notice return about 4 weeks. Mr. M.S.A. Borthakur appears for respondent 1.
1 and 4.
1 and
4.
4.
I am for 2 and 3, your lordship.
Mr. R. Boro for 2 and 3. And who's for PHE? Who's for PHE? Mr. Gogoi. P. Gogoi appears for PHE. Since the council representing respondents 1 to 5, notices the ways, extra copies be furnished within a period of 1 week from date. Steps on respondent 6 by speed post within 1 week from the date. Let the matter be listed again on 9th of January. Till the next date fixed. The disbursement of family pension shall not be given effect to without leave of the court.
Much of.
Like the notice. Item 14.
Yes.
We are in this case. In between, my lord, 86 to 1999. The present petitioner, along with many others, were appointed as female health attendant in various health centers. And a consolidated pay of ₹50 only. Subsequently, it was high, and their payment was never made. So there are several rounds of litigation. Ultimately, matter went to the Supreme Court. Supreme Court has held that we are entitled to minimum wage under Minimum Wage Act. and referred the matter to the High Court. Thereafter, High Court, after a long round of litigation, has ultimately held at page 213, your lordship will find, we are entitled to rupees 900 per month and directed to be paid page 213 relevant portion, my lord. That is not paid. Its judgment was in 2017. So now we are before your lordship, my lord. Either earlier, there are another set of petitioner applied, we filed a petition that was dismissed by the single judge on the ground of limitation. So ultimately, appeal was filed. In the appeal, that was, my lord, in one appeal, 15 petitioner, they were already paid.
No, what do you want now?
Now at this stage, my lord, we are now, our prayer is, my lord, the amount as in terms of the order of 2017, we have not been paid yet. So that has to
File
be
contempt.
contempt, my lord. Earlier contempt was filed, but it was time barred. So now we have filed the.
Once a writ is issued, it is issued. Should we keep on issuing writs?
Yes, my lord, because
Why?
earlier a contempt petition was filed by another group of 270 of petition. That was closed, giving us liberty that since it was time barred, contempt must be or to have been filed within 1 year. So since we have not filed this within 1 year.
You show us that once a writ is issued, contempt is time barred. You are entitled to come to court.
Thereafter, we filed writ petition. The writ petition was, I have annexed this order, was dismissed by the learned single judge holding that time bar. Our claim was time bar.
Correct.
This order was put to challenge. Two repeat appeal is now pending. In one appeal, already there is an order. This order I have annexed.
Which order? Where is that order?
It's 122.
222. Page 222.
222.
This is the readable 297. And the
Where is the order? Effective recital of the order.
order present. Yes? 267, 11 part.
So let us await the outcome of the appeal. Let us see.
At this is said, I am praying for issuance of notice, my lord, at this. Because 267, your lordship kindly peruse.
So why should we issue notice? Once the matter is settled, you have to pursue it. You did not pursue it. You come back to court.
Your lordship kindly, for a moment, 267 kindly.
Yes, 267.
The appellant belongs to such and such have already been paid the arrear of salary. However, in respect of the appellants belonging to such and such, the matter is under consideration and it is expected that their arrears of salary will be cleared in the current financial year. In respect of appellant in writ appeal number author learned counsel, so in another writ appeal notice issued and in first, my lord, out of 15 has.
These writ appeals are filed challenging which order?
Telling the single bench order.
Where is that single bench order?
256.
256.
Relevant part. Relevant part. Relevant part. 215. And your lordship will have from page 218, paragraph 3 onwards. And ultimately, paragraph 9, page 220. While limitation per se have not the writ proceeding, the except as laches in an inappropriate factor which this court is required to look into. In any case, as observed above, a writ court cannot be made executing court for execution of an order passed earlier. As a litigant, it is not left remediless as we can take recourse to the contempt court act with an allegation of willful and deliberate disobedience, which however needs to be filed within the time prescribed. In view of the above circumstances, the court is of the considered view that the writ petition cannot be entertained and accordingly the same may be dismissed. So against this order, two appeal filed. One is of a group of 15.
So let the appeal be decided, then we'll decide on this.
In
Otherwise,
one appeal, my lord, 297.
otherwise it is covered, we'll have to dismiss it. We dismiss it, you go in appeal.
In one appeal, my lord, it is already directed to pay our area and 4 of them has been paid. Out of 15, 4 of them has been paid.
We'll only say that there is no bar in releasing your payments if they want, but you satisfy us that we have to issue notice here in the matter. Notice for what purpose? You already have an order in your favor.
Yes.
That order you, for whatever reason,
Now,
you
we
did
have-
not come
we
to
have-
court seeking
We
compliance.
have renewed our prayer, adding interest part.
Huh?
Interest, because in 2007, it was directed to be paid within 6 months.
Now that you will have to,
So in present writ petition, our new claim is interest part. Apart from the principal, interest part.
you should have made this claim in the earlier petition.
No, earlier writ petition, there was after several round of litigation, finally Supreme Court held that we are entitled to minimum wage as per Minimum Wage Act. And matter was, my lord, remand back to the High Court to decide afresh. Ultimately, High Court by this order, my lord, I have already listed lordship, my lord, this order has decided that we are entitled to at the rate of rupees 900 per month during the
2017 order.
2017 order.
Ah.
So we are pursuing, my lord, because when petitioners are belonging from various districts, your lordship knows, my lord.
Yeah.
We are pursuing sometime individually, sometime with association. So that has not been, ultimately we came to file and contempt petition. In the contempt order, in the contempt petition, it was held that
You pursue your writ appeals, if the writ appeals are allowed.
writ appeals are separate group. Only. The present petitioner, they have come first time after
If
70.
the writ appeals are allowed
My lord.
in your favor, in whichever group's favor it may be,
My
then it will cover these issues raised here. Otherwise, it is covered in terms of the coordinate bench judgment, where the writ petition was dismissed for delay.
Then your lordship may say, my lord, in the meantime, we may be permitted to pursue the matter with the respondent authority and await till the outcome of the writ appeal.
You don't require permission of the court to pursue it. You can pursue it. Why do you want an order?
So two writ appeal is pending.
The petitioners are before this court seeking a
One thing, my lord,
direction.
may I
for-
must one submission, my lord.
Ah.
My lord, petitioners herein, my lord, 125, they preferred the writ petition jointly. They are from, my lord, from different, my lord, 7 districts. Even if, my lord, on the face of it, my lord, it will not be maintainable. But how will you, my lord, even tomorrow if notice is issued, how will you verify? Joint directors are not a party herein. And top of that, my lord, the statement made, my lord, repeatedly that the Supreme Court, Honorable Supreme Court has, my lord, directed to that they will be entitled for 900. Lordship will see, my lord, it was remanded back. There is no direction of the Supreme Court. The wrong
No,
statement.
but
being made.
anyway, there was a
No,
direction of
your lordship kindly peruse, this is the order that
Yes, yes.
Supreme Court has clearly said we are entitled
Listen-
to our.
listen to the order first. As
No, no, Supreme Court is right, they are not able to-
for taking a direction
Supreme Court.
for payment of area honorarium with effect from
Page 96, sir.
area honorarium as was
We are
directed by
entitled to as per minimum wage.
the judgment and order.
Paragraph 26. Yes, sir.
22/9/2017. Past due.
Fixed করেছি, High Court.
WPC 900 of 2013 and other connected with petitions by the said order. The coordinate bench of this court The coordinate bench of this court issued the following directions. Read it in. Paragraph 18 to 22, page number 213 to 214. So pursuant thereto, certain for non-compliance, contempt petitions were filed, which however came to be withdrawn, which however came to be closed, and liberty was granted to the respondents to pursue the matter. So meanwhile, another similar set of persons like the writ petitioners approached this court again by filing WPC 3889 of 2024, which came to be disposed of by judgment and order dated 5/8/2024, stopped by the said order. The writ petition stood dismissed. On the ground that
Paragraph 9.
the aspect of latches on the ground of latches, and also further that the writ court cannot be made an executing court for execution of an order earlier passed by a writ. This matter against this said judgment and order and appeal being writ appeal 297 of 2024 has been filed.
71 of 2025.
Huh?
Two readable filed. 71 of 2025.
And 71
71 of 2025.
and 71 of
25.
2025 have been passed, have been filed. Both these writ appeals are presently pending disposal before the Rate Appellate Court. Well, in that view of the matter, at this stage, the court is not inclined to issue notice. However, the parties are given liberty to apprise the court of further orders that may have been passed by the appellate courts, which will have a bearing in the present proceedings. The respondents will also ensure that the claims of the writ petitioner, if otherwise available to them under the provisions of law, shall be considered and shall be considered in terms of the as was directed in terms of the judgment and order dated
2017.
23/10/17.
23/10. 17 past 10 WPC number
900. 13 and connected others.
900 of 2013.
connected matters. So list this matter again after 6 weeks.
Let it be after
I'm
6 weeks, my lord. In the meantime, let them, my lord, implement the joint directors, because various districts, ultimately, the joint director will verify.
Question of maintainability, since notice has not been received, the question of maintainability is also left open.
Yes.
Yes.
May I please, your Lordship? Lordship, in this matter, Lordship, the petitioners were working as homeopathic consultants under different dispensaries and polyclinics under NF Lordship.
Homeopathic, they're homeopathy doctors.
Consultant.
Yes,
Doctors.
Doctors.
Why are they disengaged?
They were temporarily appointed.
So
As
what
per-
are they to do now?
As
Lordship.
per appointment letter,
You're not finding them effective.
normally, as per the appointment letter, Lordship may kindly come to page number.
Lordship, they are contractual employees, Lordship. And they were appointed during the period 1989 to 2003.
Where is the contract agreement?
Agreement, Lordship,
Appointment
appointment
letter.
letters I have.
Page 16,
of-
page 16 may not come.
Lordship, though they were appointed as contractual, Lordship, but they were discharging their duties since 1989, Lordship. And there are 6 petitioners. They were appointed since during the period 1989 to 2003, Lordship. And their age is between now 49 to 69 years, Lordship. And already we have discharging our duties regularly and with full
What is your
satisfaction.
prayer?
Lordship, my prayer is that they have suddenly issued one termination letter, Lordship. That is impugned Annexure 7, page number 30. Where, Lordship, without any intimation, without any information, they have terminated.
Where
And
is that order?
Annexure 30, Lordship, page number,
Annexure
sorry,
30,
Annexure
page
7, Lordship, page
page 30.
number 30. Lordship, and though I have not stated, Lordship, these were received by through electronic media, Lordship, through WhatsApp. And later on, Lordship, we have received, some of petitioners have received termination letter, Lordship. 4 petitioners have received. And my only humble prayer is that we are continuing our service since 1989, Lordship, some of us. So they were again higher, Lordship, contractual employees. So we are experienced, Lordship, and we are discharging our duties since 1989, Lordship. So our termination is arbitrary, Lordship. And
Alright,
at
you
this
get
age, Lordship,
Why
My
did
lord,
you terminate?
yes, my lord. My lordship, may kindly come to page number 17, my lord. Condition number 4.
Yes.
The engagement can be terminated with 14 days notice without showing reasons, madam.
Where is that 14-day notice?
Notice has been served to
no,
this
Lordship,
petitioner number
14
1.
days
madam.
notice
Where
we have
is-
not received, Lordship.
Petitioner has received 1.
Petitioner number 1 had received it
Yes, sir.
on, Lordship. Only 1, he has received it
How
on
many petitioners are there?
6 petitions.
6 petitioner.
Sense of petitioner 1, you have received only 1.
Yes,
Then for others, you have to serve.
yes, madam. I have to take.
He has received it on, Lordship, petitioner number 1. 14/11, Lordship. And today is his last date, Lordship. 28/11, Lordship.
You get instructions.
My lord.
Lordship, till then, Lordship, impugned notice may be suspended, Lordship.
Yes, my lord, the part-time employee and temporarily appointed, madam.
Part-time employee, Lordship,
My lord,
but
their engagement is under
Lordship,
certain
kindly pay-
conditions, terms and conditions, madam.
Heard learned counsel for parties. Petitioner before the court are homeopathic office who are engaged on contractual basis by the NF Railway. So it is submitted by the counsel for the petitioner that they had rendered. They were engaged in service since
since some of Lordship,
Various dates, ma'am.
1989, Lordship, I have stated in para-wise, Lordship. Petitioner number 1 was appointed on
which para?
para 3, Lordship. Petitioner number 1 he was appointed on 17/3/2019.
Appointed as far back as 1989 and have since been rendering their services on contractual basis. The contractual agreements which are engaged, which are executed with the petitioner and the railways provide for termination with 14-day notice. So the counsel for the petitioner submits that besides the petitioner having rendered services for all these years without any complaint, their services ought not to have been terminated by issuance of termination order, impugned order, which is 11/11/2025. So set apart in terms of the agreement, the termination can be made with 14-day prior notice. So counsel for the petitioner submits that no such notice has been issued prior to termination. Then at CGC on the other end, submits that he has no instructions. Accordingly, let instructions be obtained by the learned CGC as to the reasons as to why the petitioners have been terminated after rendering all these years of service. And whether the conditions mentioned in the contract agreement has been, insofar as the railways is concerned, has been adhered to prior to issuance of the termination order. That this matter be listed again on 19th January.
Extra copies may be supplied.
Meanwhile, the impugned order dated 11/11/2025 shall not be given effect to till the next date fixed. Extra copies of the writ petition be furnished within the course of the day. Learned CGC.
Obliged.
In 19.
May I please proceed? In this case, my lord, as per advertisement, petitioners applied for the post of my lord assistant technician assistant for central Sterling supplies, my lord, and technician for central Sterling supplies.
I can't hear you.
My lord,
I can't hear you. Why are you reading your file? You submit before the court?
yes, my lord, only 42 posts is,
Why are you before the court?
my lord, out of 63 posts, my lord.
Ah,
And the respondent authority are contemplating to fill up on peak and solve.
63 posts of what?
Although the petitioners are passed out in the written examination and
63 posts of what?
a millet, post is man, a post is millet, a pace, as per advertisement millet.
What post?
A pace 13 millet.
30. 30. You're not prepared. You read and come back Monday.
Monday.
Huh?
Monday.
Or Monday in January.
No, Monday.
Why are you appearing without reading the very brief? Matter be listed again on Monday. The request made by the council for the petition. Mr. D. Upamanu appears for health and Ms. S. Borwa for the state.
Respondent number 1.
Respond.
Highly obliged.
May it please your lordship.
Yes.
The matter pertains to non-review of the suspension order, your lordship.
Non-review
of suspension order. The petitioner was suspended on 26/3/2025, and since then, your lordship, he's under suspension, but his suspension order has not been reviewed till date. And neither any disciplinary proceeding has been initiated.
We issue notice here, right? Council for parties issue notice. Mr. A. Chakraborty, learned town government advocate, appears for respondent number 1.
Respondent number lots.
1 and 2.
1 and 2 lots.
1 and 2.
Be sure.
Yes, so and so appears for accountant general. And A. Botaku for finance department. Since the respondents are represented, notices are waived. Extra copies be furnished within a period of 1 week from today. List again on 19th January.
Published.
That is lost.
Yeah.
This case, my lord, by last order, my lord, the respondents
sir.
are directed to my lord submit instruction as to whether my lord the any
New inquiry officer has been
A new
appointed.
inquiry officer has been appointed.
And
Yes,
Lord,
Lord.
in fact, Lordship, on 27, he was asked to appear before the inquiry officer. Lordship. Next, second page, Lord.
So inquiry is going on.
Yes.
it may be directed to be decided within my lord specific period because my lord my promotion is held up like so my his juniors has already been promoted last
All right, heard. That is counsel for the parties. This writ petition is directed against the inaction of the respondent department in towards non-completion of the disciplinary proceedings initiated against the writ petitioner. Stop. The petitioner, who is serving as Deputy Director under the Irrigation Department, a petitioner who was serving as Swachhata officer, within bracket Assistant Chief Engineer, the Guwahati Municipal Corporation, was arrested on 27/7/2022 by the Chief Minister's Vigilance and was detained for more than 48 hours. Stop. He was suspended from duty and an order dated 31/10/2022. Thereafter, show cause notice was issued to the petitioner, leveling 3 charges against him. The petitioner submitted his reply. Subsequently, he was reinstated in service by order dated 12/12/2024. Stop. However, the departmental proceedings initiated have not been completed. Stop. As a consequence, the petitioner's promotion and other increments have been kept withheld, while his juniors have been promoted to the next higher post. In spite of repeated requests by the petitioner to complete the disciplinary proceedings, the same has not been completed. Better. Under such circumstances, the writ petitioner is before the court. Better. By order dated 3/11/2025, the Standing Council Irrigation Department was permitted to obtain instructions. Whereas today, when the matter is listed, the Standing Council has placed before the court copy of the order dated 24/11/2025, whereby
Paragraph 4, Lord.
whereby Sri Vishnu Kamal Bora, ACS, retired additional secretary and member, State Inquiry Officer Panel, has been appointed as the inquiry officer for the inquiry to be held against the delinquent officer. So it is further submitted by the learned counsel for the department, for the respondent, that pursuant to the appointment of the inquiry officer, the departmental proceedings have commenced, and the matter has been fixed. Matter was fixed on 27th of November, 2025. Stop. The counsel for the petitioner, however, is not instructed as to whether the petitioner had appeared on the date in which he was asked to appear before the inquiry proceedings. Be that as it may, since the fresh inquiry officer has been appointed, it is expected that the departmental inquiry against the writ petitioner is to be completed in a time-bound manner, and upon the conclusions arrived at by the inquiry officer, departmental authority will proceed to pass appropriate orders as permissible under law. Accordingly, this writ petition stands disposed of at this stage, directly the Secretary to the Government of Assam Irrigation Department to ensure that the departmental proceedings initiated against the writ petitioner are proceeded with and completed in a time-bound manner as expeditiously as possible within the outer limit of 90 days from the date of receipt of a certified copy of this order.
Subject to lordship, he participated in that.
The petitioner will,
Already inquiry was done.
Will also cooperate in order that the inquiry proceedings are conducted in the time-bound manner as directed. Once the inquiry report is submitted, the disciplinary authority will also pass appropriate orders as permissible under law with the provision with petition.
May I pray for an observation, Lordship? In the meantime, Lordship, if in the meantime, process of promotion is initiated, Lordship, I may be considered.
Even the petitioner is included in the zone of consideration for promotion to the next higher post, his case may be placed before the DPC but kept in seal cover. After conclusion of the department.
I am appearing for 3 and 4.
MS as Bora appears for respondents 3 and 4.
Motion item 43.
Make peace a lot. On praying for issuance of a notice.
Yes.
It has a bearing, my lord, otherwise, but initially, under the Assam Junior Forest Service Rules 2005, there's a requirement for promotion to the post of Forester Grade 1.
This is a contempt.
It's a contempt.
So
Apparently,
let
we
us issue
represent.
notice.
Notice.
Third council for parties issue. Returnable 4 weeks. Steps on the respondents.
Single.
Sole respondent by racial list. List after 4 weeks.
Sorry. Right, much.
44.
You know, I have received some instructions, madam. Could you please it?
Yes.
Yes.
What is the meaning of this?
What transfers that the preliminary inquiry is not yet completed.
Hmm?
The preliminary inquiry which was initiated against the petitioner on 20th of March 2024 is not yet completed.
Preliminary inquiry?
Yes,
Why?
because there was some allegation of receiving some gratification during the medical examination conducted by the petition.
Bring it on record. Let him file an affidavit here. Third council for parties issue notice returnable 4 weeks. Pursuant in deference with the earlier order passed, dated 31/10/2025. The learned CGC submits that instructions have been received. Stop as per the instructions. It is submitted that a preliminary inquiry was instituted against the petitioner. On which?
20th of March 2024.
March 2024, regarding payment of illegal gratification by the petitioner.
No, allegation was against him. Yes, by the petition.
By the petitioner.
No, my lord. By the petitioner, yes, ma'am. Sorry. Yes,
Allegation was like one of the candidate made a verbal complaint that like petitioner. along
Yes,
with-
by the petitioner.
Illegal gratification, payment of, the illegal payment of illegal gratification involving the writ petition.
My lord.
Stop. That inquiry is still underway and not completed. Stop. Under such circumstances, we permit the learned CGC to bring his instructions received by way of an affidavit.
My lord.
Accordingly, let notice issued, Journal 4 weeks. Learned CGC accepts notice on behalf of all.
All.
For notices of waived, extra copies be furnished. If not already furnished, be furnished within 3 working days.
May it please your lordship. Lordship, the petitioner herein is working in grade 4 and being the senior most, he is eligible for promotion. And he has submitted representation upon representation to consider him for promotion against the vacancies. But he has not been given promotion. In fact, in a similar matter, my lord, this honorable court has passed an order with consideration of representation. And to keep an eye on.
What's the instruction? Well, the petitioner doesn't have the requisite qualification for promotion to the next higher level post of junior assistant. After amendment of the rules, matter now it is graduation. The petitioner is a higher secondary pass, as admitted in the writ petition at para 4, page 7. Is a matriculate matter.
So, my lord, let the representation be considered like the order of rejection is there, because as of today, as per this court itself, in Dilip Chandra Kalita, there was this.
Or he's got his instructions saying that you are not eligible. What is the point in sending the matter back to
Yes,
him?
my lord, because
Because you can file the affidavit.
No, my lord.
File the affidavit.
Yes, I will file my
So, my lord, because if there's a rejection order against my representation on that ground, I can challenge that. As of today, I don't have that order. So let my representation be considered. I get the order, I can challenge because without that order, how will I be able to?
You are asking for a direction to consider you.
Yes, my lord, that.
On date, what are the rules?
My lord, as of today, they are saying that the office memorandum is not applicable. My lord, this question was put up in a coordinate bench. This is the paragraph, my lord. At paragraph 15. Whether the 99 office memorandum is in pursuance or section 6A. A recent judgment. And as of today, my lord, there is no notification as of how which is to be followed.
No, then you'll.
Dilip Chandra Kalita, my lord.
You bring it on record. What is this? You are.
My lord, this is a judgment, my lord, the judgment of this court. My lord, I'm just praying if I'm not considered on the ground which my instruction is received, I get a rejection order.
Had this instruction not been there, we would have issued a.
I absolutely understand.
Instructions are
But
clear.
my lord, today I am.
Let them bring it on affidavit.
I will file my affidavit.
May I just submit one thing, my lord, here, please? My lord, if without the rejection, if my representation is considered and if I reject it, my lord, the entire matter, I can at least challenge my rejection order. Now
When the court is open to issuing a direction,
my lord,
where is your difficulty in asking that the matter should be relegated to the department to dispose it?
my lord, I just go down, my lord, because this notification has not been, and this representation of mine has not been even given order.
Therefore, we are saying that let us consider the matter.
My lord. At least a post may be kept vacant, my
Why
lord.
did you want? If you don't want, we'll close it.
My lord, I prefer, my lord, considering the representation and then coming with the order.
Heard learned counsel for the parties, the petitioner before this court. He is aggrieved that a representation filed before the authorities. Where is your representation?
My lord, my representation is at page number. Page 36, 37 and annexure 5, annexure 6 and annexure 7. From 36 to 40.
Which representation do you want? They can't consider 3 representations.
My lord, annexure 7, page 38.
38.
Yes,
By the representation dated 27/10/2025. Which according to the petitioner has not been considered by the respondent authorities. The petitioner is agreed that his case has not been considered for the promotion to the next higher post, as has been done in case of others similarly situated candidates. No. In terms of the last order, the standing council has been posted with the instructions that in terms of the amendment carried out, the Assam Ministerial Service Rule 1967, the educational qualification for promotion has been raised from higher secondary to graduate or equivalent degree. Since the petitioner is not a graduate, his case was not considered. Be that as it may, since the case of the petitioner since the representation of the petitioner is still pending, the authorities will consider the matter in its, as per provision of law and pass effective orders thereof disposing of the writ petition. Any such speaking order that is passed, a copy thereof shall be served on the writ petition. This entire exercise we carried out within a period of
4 weeks.
60 days from the date of receipt of the relevant copy of this order. Needless to say, the writ petition stands disposed of without expressing anything on the merits.
Much obliged, ma'am. I humbly oblige, ma'am.
That being boss. My lord, in this case, the petitioner was appointed as Gaura. My lord, due process of selection, my lord, the advertisement was issued on
Appeal
7.
filed. Appeal.
Appeal was disposed of, lordship. In the case, my appeal was allowed, lordship. The petitioner's appointment was cancelled, set aside by the, my lord, appellate authority now. Now that is at page 77, lordship.
Appeal filed by whom?
By the respondent number 5.
By
An unsuccessful candidate, he is not matriculation, lordship. My lord, he is just.
You were the selected candidate.
Yes, I was the selected guy. I was appointed in 2023.
And
My lord,
five
unsuccessful, my lord, grandson of the my lord,
All right.
previous Gaura.
Against this appeal, there is a review or a revision. Review. You prefer a review? Under
162D.
D.
Lord,
Is a
review. Many cases, my lord, without review, my lord, and appeal, the petition is entered.
There is a review. Yes. We'll direct them to dispose it off within a specified time.
Lordship, till then, my lord, some protection may be given law.
You are still in charge.
Yes, lordship.
No, Lordship, my lord, kindly see the order, Lordship. Appellate order. It is rightly, well,
Appellate
about this
order.
order.
Appellate order.
At page 77, lordship.
Relevant portion is Lordship 79. No? Lordship, analysis and findings, Lordship. Bill number 1 in the middle portion, upon careful, Lordship. Upon careful and perusal of and scrutiny of the mark sheet placed on record, it is manifest that the appellant secured a total average of 23.33 marks, whereas the respondent number 5 has obtained a total average of 33.33 marks. It is an disputed position that the undisputed position is that the appellant has duly granted preferential mark of 10, to which is entitled by virtue of being the member of a family member of the former Gaon Pradhan. This aggregate should have to stood at 33.6. You know, equal marks. Lord. It is my lord that 10 marks is given, and therefore, my lord, this appellate authority was directed to the deputy commissioner to according to the fresh selection process. Lord.
My lord, the respondent number 5 himself is not, my lord, eligible for the post, lordship. He is not matriculation. He has completed, my lord, class 9, lordship. The required qualification is class 10 pass, lordship. And my lord, on the other hand,
how can he apply?
that is not only from the point.
You appeared before the appellate authority.
Yes, lordship. I submitted objection, my lord. I raised that the respondent number 5 has no qualification. He has completed, he has passed the class 9, lordship. RTI application reply was submitted that he is just registered in class 9, lordship. No metric examination, class 10 examination, no leave certificate, nothing is there, lordship. So if the respondent number 5 himself is not qualified, that eligible, that answer, that has not been answered by the appellate authority, lordship. My lord, how my appointment is silenced and my lord, appointment is set aside, lordship. My lord, everything has gone, lordship. Preferential right, my lord. On the other hand, my lord, the son of the my lord previous Gaura nephews, 2 nephews also applied for preferential rights. How the grandson can claim he has no qualification, lordship. He has no landed property.
Very good job. But these have not been answered by the appellate authority.
Yes.
Also, I am appealing for the respondent of 5, lordship.
Ah.
Because this board before the authority, the responsibility of 5 is the.
No, without my lord, that qualification, he cannot appear in the my lord, the selection process. Your Worship. As per the advertisement, it is.
No, that's all right, but if the objections are raised, it has to be dealt with by the appellate authority.
Let them go
Appears
for
to
the
not
review.
be
Lord.
dealt with.
And also lordship, landed property is a preferred eligible criteria lordship, the petitioner has no landed property. This is also one of
The respondent number 5 has also not landed property.
That landlords as because my lord, they have the my lord, they are possessing their father's property lordship. That this dispute my lord cannot be.
As per application for father's properties, my lord.
Without allotting the lordship marks fixed.
Lordship, let them go for the another review lordship.
My lord, then I may be protected, lordship.
No, as per the order, his passed. Was passed on 11 November 2025.
That is why I am before your lordship.
The appeal is admitted or what? It is.
Admitted.
Huh? Disposed of or what?
Yes,
Dispose of.
Or it is still being continued?
No, dispose of.
But it says the appeal is admitted.
Language is this lordship, my lord, that language is there. You set
But
aside
it
that
is-
was
it
the
is not
immediate
pending.
effect.
Appeal is allowed.
It's allowed, not
It should
pending.
be allowed,
Not pending.
not pending.
My lord, in the appeal, my lord, the correspondent number 5 did not mention his qualification. His, my lord, how
No,
he
you
applied.
File a review.
My lord, that is my, I may be protected till then.
Who will protect you?
Yes, lord.
Third letter counsel for the petition is. Writ petition is directed against the order. Speaking order dated 11/11/2025 passed by the Directorate of Land Records and Survey, whereby the appeal preferred by the private respondent against the selection and appointment of the writ petitioner as the Gaon Pradhan for lot number 5 of Duarpara/Dongpara under Pochim Dolgaon Mauza in the Dolgaon Revenue Circle, Dorong District was interfered with, was allowed, and the selection and appointment of the present petitioner was arraigned as respondent number 5, said appeal was set aside and quashed with immediate effect. The learned counsel for the petitioner submits that the objections raised by the writ petitioner as a respondent before the appellate authority were not considered by the appellate authority while deciding the appeal. It is submitted that the private respondent / the appellant before the appellate authority did not fulfill the eligibility criteria as he did not have the required educational qualification. He did not have landed properties and politically affiliated.
Matriculation certificate, lord. He has just passed, my lord, class 9, lord.
And according to the petitioner, the private respondent has only studied up to class 9 and is not a matriculate. So therefore, the writ petition is filed, saying the order passed by the appellate authority. Mr. A. Hendick,
One and two.
counsel representing respondent number 1.
1 and 2 lords.
1 and 2. Submits that there is another forum prescribed under the executive instructions 162-D. So under the same provisions, against an order passed by the appellate authority, a review lies before the state government.
Lordship.
So that remedy has not been availed of by the writ petition. You are on caveat.
And for respondent.
You filed a caveat. Where is the caveat? Someone did Idigo. RDMS R. Devi. Learned council, caveat kon upor thoi diye. RDB, the council representing the caveator who's arraigned as respondent number 5. Caveat discharged. Then we got Mr. D. Sutia, additional senior government advocate, appears for respondent 3 and 4. And the MSR Devi appears for caveator, respondent number 5. Stop. Upon perusal of the executive instructions appended to the Assam Land and Revenue Regulations 1886, it is seen that under the said executive instructions, which stood amended by executive instructions 162-D, the review is maintainable against orders passed by the appellate authority before the state government stop. In cases of revenue matters, the appellate authority in the state government will be the secretary.
Additional chief secretary,
Additional chief secretary of Department
revenue and disaster management.
Department of Revenue and Disaster Management. So, considering, although alternative remedy, not an absolute bar in entertaining a writ petition, considering the fact that the issues raised contains substantial factual issues to be decided, this court is of the view that the petitioners can be relegated to file a review as prescribed under Executive Instructions 162-D, as according to the court, such statutory remedy ought to be availed of by the parties in view of the actual issues involved in these matters. Stop. Accordingly, without expressing anything on merit, writ petition stands disposed of, directing the additional chief secretary, Department of Revenue and Disaster Management, to permitting the petitioner, permitting the writ petition disposed of, permitting the petitioner to file a review as prescribed under Executive Instructions 162-D before the additional chief secretary, Department of Revenue and Disaster Management, Government of Assam, within a period of 1 week. How much time?
2 weeks
take to file the review?
10 days most.
2 weeks. 2 weeks from today. Stop. If the petitioner prefers a revenue as permitted, the review as permitted, the authority, the additional chief secretary, Department of Revenue and Disaster Management, Government of Assam, being the prescribed authority to hear and dispose of the reviews filed under Executive Instruction 162-D, will endeavor to dispose of the review within a period of how much time? 60 days. 60 days.
60 days.
The respondent of 5, we have to put in the procedure.
90 days.
Lordships.
90 days from the date the appeal is filed. The review is filed by the petitioner. Stop. Needless to say, the private respondent number 5 will also be permitted to participate in the said proceedings, for which will also be permitted to be participated by the said authorities. Let this decision be let the review as permitted to be filed be decided within the prescribed period of time by passing a speaking order as expeditiously as possible. He decided within the time prescribed with the outer limit of 6th of March 2026. In the till the next date, till the review petition is decided. The finally decided by the authorities, the appointment of the petitioner shall not be. The petitioner shall be allowed to continue in his post till the review petition is decided. Stop. If the review is permitted to be filed is not filed within 2 weeks as permitted, the interim order will not hold field. This post.
Offline does.
Obliged.
47.
Yes.
The matter relates to selection and appointment of constable in armed forces. An advertisement issued by the SSB Your Lordship for filling up the 39,418 post. The petitioner successfully completed computer-based examination as a physical test, but in the medical examination, detailed medical examination, he was rejected, found unfit. In fact, space 44.
What is at this stage? What else can be done?
Maybe. Till date, Your Lordship, one post may vacant, all because I am submitting under.
Lordship, PST result was not declared till now.
The interview is continued till for 12 Your Lordship.
You must clear the PST.
He PST cleared PST and computer-based examination also cleared, but the result was not declared. Result has
That
not.
the medical
See,
report is continuous, Your Lordship. Till
Medical examination is continued.
Your Lordship kindly found, Your
But
Lordship.
he is found to be medically unfit.
Unfit, Your Lordship. Knock-knee and stammering is speech disorder, but I have some documents, Your Lordship, after that examination.
We will have to examine this matter.
Yes, that's right.
Learned counsel to the parties issue notice and in those 3 weeks. MSS, BOL and CBC represents all.
Yes, sir.
Therefore, notices are waived, extra copies will be furnished within a period of 1 week from today. Respondents may file their affidavit in the meantime. List again after returnable date.
It's a day. Already I have annexed the documents of after medical exams. I have examined by the medical college GMCS. Last year also he appeared and I found that fit. Last year he appeared and same both.
21st of January. 21st January.
Obliged.
48.
Based on my lord, implementation of the my lord 7-pay commission, my lord, the government of India, my lord, Minister of Home Affairs, my lord, introduced my lord risks and hardship allowance to the my lord CAPF personnel, my lord, and accordingly, my lord, the
You
petitioner,
have
my
passed some orders here.
lordship, my lord.
You have a copy of that order.
I have annexed, my lord, page 63, my lord, relevant portion is page 84, that is disposal of matter, my lord, and another my lord at page 99, my lord, that is pending, my lord.
Page 60.
Page 63, my lord, its relevant portion is at page 84, my lord. It starts, my lord.
Heard learned counsel.
Say disposal of matter, my lord, for my lord,
We have passed in similar orders, I know where the risk and what hardship allowance. Issue notice, we can remove 4 weeks. Until further orders, no recovery shall be made. No recovery.
Lordship.
Yes.
Ablaye.
Mr. A.K. Doctor, appears all arrests. For notices of waived, extra copies be furnished within a period of 1 week. Or order as ever side over. Yes.
Ablaye.
This is my lord, challenging the transfer order, my lord, the imprint order is at page 29. The petitioner, my lord, his child is appearing in the board examination in the February, my lord, 17th February. And during this, my lord, period, he has been transferred, only staying in the now 1 year, 8 months, my lord, not even 3 years, my lord.
So, but there is a circular that you will have to first go and join. Yes. In the place and then you challenge it.
He is not released, my lord, he is not released, but just I'm just, your lordship may see, I filed my representation also at page 30. And then, lordship, my
You have to
child,
Go and join. Go and join, we will examine your.
Yes, then submit a representation, my lord.
because I let my representation at least be disposed of, that has also not been disposed of, my lord. And there is no public interest, my lord, because the person who has been transferred from Tinsukia,
Where is your representation? 30?
yes, page 30, my lord,
30.
30.
All right, we'll direct to dispose of the representation within how much time? 2 weeks.
2 weeks.
Till then, my lord,
Till then.
no courses that should be taken, my lord.
Till then. All right, heard learned counsel for the petitioner. The petitioner is agreeing.
Regular means.
Where is the transfer order?
Transfer order is at page 29, my lord.
Agreed by the impugned.
Ground.
Transfer order dated 11.
Regular menstrual problems.
Whereby petitioner, Sri so and so, number 2, serial number 2, has been transferred from Dhokapana ICDS project Lakhimpur to Silchar ICDS project Achan. The grievance of the petitioner is that he was earlier transferred and posted in his last place of posting
Dhokwakhana, my lord.
within, when was he transferred?
1 year,
last?
8 months, my lord.
Huh?
Within 1 year, 8 months.
Within 1 year, he was last
Transferred on
and
7/3,
posted in
2024.
last place of posting. And he's now again being sought to be transferred by the impugned order within a period of 1 year, 8 months. So, he submits that this is violative of all government notifications and guidelines, and there is no specific reason as to why the petitioner has been transferred. Pursuant to the order of transfer, the petitioner filed an application before the Additional Chief Secretary, Women and Child Development Department, requesting for reconsideration of the transfer order. The petitioner has ailing parents and minor children. Stop.
Page 31 may be seen, my lord.
His parents suffer from severe health ailments, as also his wife. And both his parents and his wife require constant medical treatment and checkup. Stop. That apart, his son, one of his son, is appearing in the CBSE boards, which are scheduled to commence from 17 to 2026. What is this? I have not grown my salary. Page 30.
Actually, sometimes salary they are paid once at a time, my lord. After for some period they don't get the salary, my lord.
Contextually.
That is.
That apart, his salary has also from 2023 has also not been paid. Under such circumstances, he is represented before the respondent authorities to look into his grievances and reconsider his stop. That application filed on 13th, that representation filed in 19/11/25 has not been disposed of, stopped being agreed. The present writ petition has been filed. After submitting for a while, Mr. J. Roy, Senior Counsel, assisted by Mr. R. Hazarika, submits that at this stage, the respondents be directed to dispose of the representation and till such time, the impugned transfer order be kept in abeyance.
Let it be 1 month, my lord, 1 month period.
The
2 weeks. Why 1 month?
Mr. T.C. Sutia, learned counsel representing the respondents, submits that the writ petition, the writ petition can be disposed of, permitting
weeks.
the respondents to expeditiously dispose of the representation. However, no interim order be issued, as the petitioner is under the government circulars issued. Petitioner is required to go and report in his place of posting. Considering the submissions made and considering the fact that there appears to be a representation pending before the authorities concerned, which is shown to have been received by the departmental authority, this court proposes to close the writ petition at this stage, directing the Additional Chief Secretary, Government of Assam, Women and Child Development Department, to look into the grievances ventilated by the writ petitioner by way of the representation file and to dispose of the same as expeditiously as possible within a period of
2 weeks.
1 month.
He will say after 1 year. I will say 2 weeks.
all right. Within 3 weeks from the date of receipt of a certified copy of this order, which can be submitted either by the petitioner or by the respondent counsel. So, any such speaking order that is passed, needless to say, it shall be served on the writ petitioner. Let this representation be disposed of. Be disposed of and within 19th of January 2026 interim order, the transfer order, impugned transfer order dated so and so shall not be given effect to insofar as the writ petitioner is concerned. But what will happen to the other person?
He's in his place, my lord. He's not. I've mentioned in para, my lord.
Till 20, still which date we said? 19th January.
Obliged.
Date certificate.
Obliged.
Okay, so far as the writ petitioner null, impugned transfer order shall not be given effect.
50.
Lordship, may pass for time.
Lordship, we can dispose of this matter, my lord. Item 46 is a similar, lordship.
Review.
Review, lordship.
You can, my senior word, lordship. My senior word, lordship.
Timing. Yes. What was the item number that we disposed of?
46.
46.
Lordship, we kindly take it up after some time, Lordship. Mr. D.P. Bora is appearing in this case. He is on lakes, Lordship. After some time.
What is it that you want?
My lord, on the basis of a complaint by a lady, my lord, proceedings under the Sexual Harassment Women at Workplace Prevention and Prohibition of Adversarial Act 2013 was initiated.
300123 At page 8, my lord.
So where is the-
Relevant is
where is
paragraph
the
9, my
report
lord.
submitted?
My lord.
Report submitted before the court.
My lord.
CID report?
Yes, my lord. And that has been considered by the order dated 8/12/2023, my lord. Just now I had placed annexure 5.
Uh,
And the CID report is possibly in the read petition, my lord. I'm not in the read petition, my lord.
So what is to be done today?
My lord, on a similar matter, my lord, generally what happened, my lord, if the read petitioner files petition by making false statement, my lord, a criminal case has to be registered against him, my lord, by the registry, by filing FIR. And we are repairing few cases in similar nature.
So where is that report?
My lord. And I will place the report, my lord.
You examine and tell us.
My lord, my lord. Yes, my lord.
Let this matter be listed again after a week, enabling Mr. Bushel and a council appearing for the registry report to place before the court all the relevant materials relating to suo motu contempt proceedings initiated. Mr. R.M. Chaudhary appears for the writ petitioner.
My lord.
After 1 week.
All right.
I think 50.
None appears passed over for the day. None appears on second call.
51.
Yes.
May it please your lordship. My lord, there was a complaint lodged against me at page 26.
Yes.
This was treated to be a complaint under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Accordingly, there was an inquiry committee. That's lordship finds at page 28. The matter was referred to the inquiry committee. I'm not reading the details, I'm just indicating, you know. And eventually, after statement of the complainant and the petitioner's statement were recorded, at page 38, the inquiry committee's report comes. That would be relevant. Page 38 is the inquiry committee report. Everyone examined all statements taken. Sorry. The operative part would be at page 39. It's one paragraph. May I read that?
Yes.
After hearing the statement from the complainant and receiving the written statement from the alleged, the internal committee has not been able to come to a conclusion due to lack of supporting evidence from both the parties. Therefore, the committee requests the district administration high authorities to look into the matter. The committee also suggests suspension of the alleged until completion of the investigation. Now, my lord, so far as the conclusion is concerned, there is no evidence. However, most illegally, they had suggested the suggestion. This, eventually, I was put into suspension also, and the order of suspension is at page 53. I'll not take your lordships to there. I challenge this suggestion, simpliciter, and the order of suspension by filing a writ petition, that's 4916 of 25, which is pending. During the pendency of that proceeding, my lord, show cause notice was issued to me, and that my lord finds at page 57.
Hey, who's to appear in health? Health. SC health. Item number.
That was at page 57. It's okay, it's properly drafted. There's a show cause. The charges, their statement of allegation, list of witnesses, list of, everything is there. This continue. No, my lord, this is the second proceeding. The third one was, my lordship would find at page 42. 42. '41. The first one is at 40, 41, 42. I'll take to 40. This is when the Joint Secretary, Government of Assam Health and Family Welfare Department issued to all the persons. May I read below? Yes. With reference to the subject cited above and in pursuance of the letter under reference, you were requested to appear for a hearing. Now they asked me to appear for a hearing. At 41 also, they asked me to appear for the DC's office. This again, proceeding, continuing against me. Lordship was done. Now, yet another, at page 27, they proceed against me.
So it is the same proceeding.
At no,
Huh?
so far as the
ICC
ICC is concerned, no, ICC is over.
They've completed.
ICC is over.
Completed.
Now, under the law, I'll place it below. ICC is over. Now they start DP. They call me to the DC office. That's a different issue. Not connected to DP. And at page 27,
No, DC's office, why?
for a hearing
On-
on the complaint. That's absolutely expressly illegal, my lord. Now, at page 27,
You are employed under the health department.
Your Lordship, I've given my details. I've given my details.
So
below.
health is not.
I'm serving as the head assistant, office of the additional chief medical health officer, Sribhumi.
Now, is the health department undertaking any inquiry?
So far as the DP is concerned, which my lord finds at page 57. This has been issued by the Director of Health Services, Assam, Swasthya Bhavan. Now, what I am on, Bingo, if Lordship would have, I've given it, so far as 2013, 1 SCC, page 297. I've given the list of books, it's very relevant. What is the status of the inquiry report after the inquiry under the Sexual Harassment Act?
The iPad holder. Huh.
My lord, earlier after the Vishaka judgment, it was said that the corresponding service rules would have this provision. After this judgment, there was a direction from the Apex Court to all the states and union territories that will incorporate. If the inquiry report is against the alleged person or the respondent, as the case may be, then it would have the status of an inquiry report as in the DP, and you proceed. If not, end of the matter, that the Act also says. So therefore, once the inquiry report under the ICC, under this Act of 2013, has nothing to do with me, the simultaneous initiation of departmental proceeding is vitiated under law. And that appointment of one man to appear and to appear before DC, all these proceedings are bad in law.
Where are the provisions of the Act?
Absolutely.
Prevention of sexual harassment. Prevention of sexual.
Extras, আমাকে এরকম করবেন।
Yes.
Right. Chamber clear the problem. My lord would have section 9. Two 2013 Act. Lordship is there, may I read section 9? I don't have this book.
We are trying to get it. Yes, section
9. I'm not going to 9. I'll just indicate how it works out. Section 9 is the complaint of sexual harassment. Once this is 9, now there's an offer given. If the committee, the internal committee, or the local committee, as the case may be, at the request of the aggrieved movement, might moot conciliation. If they arrive at a conciliation, fair enough. If they do not, then the jurisdiction to inquire into the complaint comes into play. The inquiry is under section 11. Now, once this inquiry is done under section 11, my lord would have 13, the inquiry report. Inquiry report, may I read? 13.1.2. On the completion of an inquiry under the Act, the internal committee or the local committee, as the case may be, shall provide report of its finding to the employer, or as the case may be, the district officer within a period of 10 days from the date of completion of the inquiry, and such report be made available to the concerned parties. That's okay. 2. Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the correspondent has not been proved, it shall recommend to the employer and the district officer that no action is required to be taken in the matter. I'll skip 3. It says what happens if it comes to the otherwise conclusion. Then deduction, then take action for sexual harassment, etc. would follow. Now, so far as this act is concerned, 2013,
Yes.
the status of the inquiry report vis-a-vis a DP under the service rules, there was a gray area. This part was taken care in the Honorable Apex Court judgment. That's Medha Kotwal Lele Menot. That's 2013 1 SCC 297. And the operative part would be at paragraph 44 with the directions in tune in sync with the Vishaka judgment and following further where penned down. 44.
2013
Volume 1, Supreme Court cases, 297. May I read 44 for a moment?
Just a minute.
Hold on. Inquiry status.
Yes, para.
My lord. 44.
Yes.
Mayor, in what we have discussed above, we are of the considered view that the guidelines in Vishaka should not remain symbolic, and following further, directions are necessary until legislative enactment on the subject is in place. 44.1. The states and union territories which have not yet carried out adequate and appropriate amendments in the respective civil service conduct rules, by whatever name these rules are called, shall do so within 2 months from today by providing that the report of the complaints committee shall be deemed to be an inquiry report in a disciplinary action under civil services conduct rules. In other words, the disciplinary authority shall treat the report findings of the complaints committee as the findings in a disciplinary inquiry against the delinquent employee and shall act upon such report accordingly. The findings and the report of the complaints committee shall not be treated as a mere preliminary investigation or inquiry leading to a disciplinary action, but shall be treated as a finding or report in an inquiry into the misconduct of the delinquent. If I pause for a moment, Milo, and rephrase my submissions. Prior to the act or the Vishaka judgment, it was absolutely gray area. Then came the legislative field in the framework. Now, when the service rules and the special legislation held the same field, the interplay was spelled out by the Honorable Apex Court in this judgment. Therefore, if the inquiry committee in its report acted in terms of 13.3, where it holds that the allegation has been proved, then the recommendation of the service rules being invoked comes into play. 13.3. Lordship, have it? I may read. Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has been proved, it shall recommend to the employer or the district officer, as the case may be, 1, to take action for sexual harassment as a misconduct in accordance with the provisions of the service rules applicable to the respondent, or where no such rules have been made in such manner as may be prescribed. 2, to deduct, notwithstanding anything in the service rules applicable to the respondent, from the salary or wages of the respondent, such sum as it may consider appropriate to be paid to the aggrieved woman or to her legal heirs as it may determine in accordance with the provisions of section 15. My note, this is when they hold that it has been proved. Once the inquiry committee submits its report after a long drawn proceeding, that there is no evidence, nothing left, the suggestion for suspension is under challenge, albeit. But when you had that report, they did not act in accordance with law, in accordance with the law laid down by the Honorable Apex Court, and they did not treat the inquiry committee report to be a report on which they could not have initiated a DP. I am not that the procedure they're following is wrong in the DP. I'm saying the initiation is bad, and resultantly the continuation is bad.
Essentially, what you're saying that is under these proceedings, under 13.
My lord.
Under 13.2, once they come to a conclusion that there is
not proved,
no allegation,
my lord,
or not available,
DP cannot be initiated.
then no action is required to be taken.
Therefore,
in the matter.
My prayer, Lordship finds.
Now, assuming it is under 13.1, what is the procedure?
My lordships.
Or 13.3 rather?
So 13.3. When the 13.3 comes into play, Lordship has seen there's a direction that to make suitable arrangement in the conduct rules or whatever name it is called in the service rules. So that inquiry report would be taken to be an inquiry report under the DP. And then the recommendation goes to disciplinary authority who would take consequential action after putting me to notice. So this part goes there. There's no requirement to examine the witnesses. Even we have the Honorable High Court judgment on that also. So it's basically a leapfrog jump from one act to another. If it's a sexual harassment case, 2013 Act takes care until the inquiry report, all evidence, whatever done. If it goes against the person, delinquent, then as a misconduct, it moves on to the service rules. Service rules starts from the inquiry report, gives me a copy, proceeds to the disciplinary authority, and the things follow. If it is aborted by 13.2, then there is no DP. Cannot be a DP. It has to halt there. So therefore, in my most respectful submission, Mira, the prayer which I've made at page 20, the various branches and the limbs of inquiry, proceeding, DP, which then is ex faci bad in law. I'm not on how they conduct. They could not have initiated. I'm on that.
Yes, Mr. Bora.
Well, notice may be issued and I will take a inspection, my lord. But otherwise, my lord, the report says, my lord, the inquiry report of the inquiry committee at page 39, my lord.
They could not find anything.
Yes, my lord, inconclusive. It
Then-
says that due to lack of supporting evidence from both the parties. So it seems that the report is inconclusive, my lord.
So inconclusive means, is there anything to come?
So there is a scope for further.
No, where is the scope, under what provision? And who will conduct the inquiry?
Yes, my lord. My lord, I will obtain instruction.
But I prayed for his stay, otherwise everything goes against me.
And Mr. DP Bora appearing for the Department of Health. And Mr. A. Chakravarti, council representing the respondent number 78.
In this one.
The petitioner before this court was employed as upper division assistant. He was employed.
My lord, my employment was, I'm
Upper
presently
division
posted.
assistant in the office of the additional chief medical and health officer, Sri Bhumi. And because of certain allegations made against the petitioner, proceedings under an inquiry was conducted by the ICC under in terms of the Sexual Harassment of Women at Workplace Prohibition and so Act 2013. So the counsel for the petitioner submits that the inquiry concluded that no specific conclusion can be the ICC could not arrive at specific conclusion due to lack of supporting evidence from both the parties. So, the committee, however, requested the district administration / higher authorities to look into the matter and also suggested suspension of the petitioner until completion of the investigation. The learned counsel for the petitioner submits that pursuant to such recommendation of the ICC, the district authorities have initiated a proceeding against him by issuing a show cause. And what about health department?
They issued the show cause. They also mooted the authorities that there would be inquiry by one-man person. They proceeded on that.
So the show cause is issued by the health department.
Director of Health Services.
So show cause was issued by the director of health department. And also proposal has been sent to the district authorities to pose the matter inquired into by
Srimati Anshulekha Dr. Pathak, ACS, who's have been arrayed, my lord, as the respondent number 10.
Page number
5. I mean, that's the order is at page 27. Communication rather. We have arrayed that person both by name and as by the designation.
illegal. Health department, to continue, health department has instituted an inquiry to be conducted by an officer. pursuant to which they have issued notice to you.
Yes, I'm appearing there also.
Okay.
DP and these are parallel things going on, Milo.
No, how many inquiries are going on?
Yes. The first one, ICC, it's gone.
That is gone.
Second one, this one, the one man,
No, the second one is page 27.
page 27.
Then
Third one is DP.
DP by?
DP by the health department, which they have initiated against me, Milo. That's at page 57. And the fourth one,
Thereafter, departmental proceeding has been initiated against the writ petitioner by issuance of a show cause
11 September 2025.
11/9/2025. And then
Then the DC office also calls me at page 40. Calls both the complainant and me. Come here, page 40.
okay,
41, sorry, 41.
that apart, a hearing is also conducted by the additional District Commissioner Health, Sri Bhumi, whereby the petitioner by notice dated 20/03/2025 has been called to attend the hearing. So it is submitted by the council for the petitioner. There's all these consequential and subsequent inquiries undertaken by the health department, the district administration is contrary to the mandate of the Act, Section 13(2) of the Act of 2013. It is submitted that once the ICC comes to a conclusion that there is no evidence, the matter ends there and no further inquiry is contemplated under the Act of 2013. So therefore, these subsequent actions against the writ petitioner is contrary to law and should therefore be interfered with, set aside, and the matter be put to rest. There are Mr. D.P. Bora representing the health department as well as Mr. A. Chakraborty appearing for the state respondents. Submitted at this stage, they have no instructions. They will seek a leave of the court to complete their instructions. Having heard counsel for the parties and upon consideration of the submissions made, as also on perusal of the provisions of the Act of 2013, it is seen that the ICC, which was constituted under the Act of 2013 to undertake the inquiry in respect of the complaints submitted by the complainant, in its report dated
18th of March.
18th March 2025, had concluded that due to lack of supporting evidence, the internal committee could not come to any conclusion. However, the committee requested the district administration and higher authorities to look into the matter and further suggested suspension, recommended suspension of the petition. Stop. But upon perusal of the provisions of the Act of 2013, the power to make inquiry is vested on the Internal Complaints Committee. And once the committee comes to a conclusion that the allegations are not proved, no further inquiry is contemplated in terms of the Act of 2013 for the same allegation. Under such circumstances, prima facie, this court is of the view that at this stage, notice is required to be issued to the respondents. Notice issued, returnable under 4 weeks, and
Page 23.
matter be listed again after the returnable date on 1st of Feb, 2nd of February. Till the next date fixed, all consequential inquiry which have been undertaken by the Department of Health as well as the district administration shall remain stable.
That indication at page 23, that indication be there, there are quite a many.
What indication?
Put it down serially, what are pending continuance. That A, B, C, D, E, F method, those are the things, nothing more.
It will already go, page 23. Following inquiries will remain stable till the next.
I'm grateful.
Fixed.
Right.
For order, I think 36.
May village lordship. Non-compliance for Annam High Order 19 to 2024 lordship. Annexure A page 13 to 19 lordship. And operative portion lordship page 15 lordship.
Who is for the respondent? Yes.
36. Lordship, I am appearing for the finance department. Yes. Here, in this matter, Lordship, on the last date, we had produced a letter where we had asked for certain clarification from the department regarding the date of appointment. So they have already decided by the Honorable Lordship in page 15 Lordship, para 2 and 3 Lordship. No, regarding those two appointment letters, Lordship.
Yes, respondents, who is supposed to comply?
No, Lordship, we were supposed to give we just asked the details and the clarification why there were two dates mentioned, Lordship, that clarification. So on the basis of that, the instruction
Yes.
Uh, Lordship, after finance department's address, it's under process. We will send a reply to the finance department as soon as possible. But Lordship, we have already submitted the all documents after verifications to the finance department.
Pursuant to the pursuant to the proposal sent by the administrative department in terms of the directions contained in the order dated so and so, passed in WPC so and so. The finance department raised certain queries. So, learned counsel representing the respondent number. Four, 5. 4, 5, 6, 7. These are what? Respondents. All these are respondents.
Yes, Lordship. 2, 3, finance department 2, 3.
Finance, no, not the respondent number 1, respondent number
4, 6.
4.
I'm for 1,
5.
4, and 6.
Huh?
I'm for 1, 4, and 6.
1, 4, and 6.
6.
What about joint director? Executive officer, who's there? Counsel for respondent 1, 4, and 6. 1, 4, and 6.
Lordship, 7 also I am not there.
You don't know who you are representing.
Lordship, I'm for 1, 4, and 6.
1, 4, and 6
Six.
submits that the clarifications are in the process of being communicated to the finance department. He prays for further 2 weeks' time. Let these clarifications be furnished by the Panchayat and Rural Development to the finance department so that the directions contained in the order dated 19/2/24 passed in WPC so and so 7397 of 21 can be complied. List again on 9th of January. In the event the steps for compliance of the orders are not taken, court may proceed to issue consequential orders on the next day against the respondents.
37.
My lord, person number 2 and 3, my lord, implemented and steps were taken, my lord. But still. my
Service
lord,
report on
services,
2 and 3 not received.
My lord.
When did you take steps?
My lord, on my lord, as per,
1410.
my lord, 14th
Await
October.
service report on respondent 2 and 3 list matter after 3 weeks.
My lord, registered may be directed, my lord, direction may be issued, my lord, to the register for, my lord, take consentment of the. It will,
Let it come after 3 weeks, let us see.
Lordship,
my lord, 2 weeks will be given.
3 weeks.
Lordship, today I file wakalat number for respondent number 2.
2.
Lordship.
We await service report on respondent 3. MS N. Bora has appeared on behalf of respondent number 2. List after 3 weeks.
God bless, please.
Please, your lordship. Lordship, we have filed our dossier affidavit, lordship. Respondent numbers 3 and 4, they refused to accept notice, lordship.
Where is the dusty?
Lordship, it has been, lordship, this is on record, lordship. Dossier affidavit, lordship.
Refused to accept.
Yes, lordship.
Who are these respondent 3 and 4?
Lordship, the matter pertains to notional seniority, lordship. The petitioner claims to be between serial numbers.
Has
on the-
it's been issued by speed post.
Lordship, it has been through speed post as well as through dusty, lordship. Both the means, lordship.
Lozima Court order dated 24/11/25 reflects the respondent 3 and 4, although were sought to be served notice by way of dusty, refused to accept the notices. Under such circumstances, the court will now proceed ex parte respondent 3 and 4. List this matter for admission after 2 weeks. MSS Borua IPS 4,
1 and 2.
1 and 2.
Obliged.
Please, your lordship. Lordship,
Daily card awaited
yes, lordship. As per office note dated 21/11.
as per office note dated 21/11/25. Steps, service of notice on the sole respondent is awaited, list again after 3 weeks.
Office.
41.
Yes,
I agree, your lordship. Lordship, new incumbent has joined. Kindly allow us to implement the new incumbent.
any objection from
No,
the
Your Lordship,
respondent?
we don't have any objection.
Heard. So and so, I has been filed seeking implement of the new incumbent to the post of managing director, ASTC, as the earlier incumbent who is arrayed as respondent number the sole respondent has demitted office. So counsel for the applicant submits that in spite of the directions contained in the order dated 1/8/2022 passed in WPC 3016/2019, which was whereby the termination order of the writ petitioner was set aside. This is the order.
My lord,
You were not reinstated,
my lord.
not reinstated. The petitioner was not reinstated. Being agreed. The accompanying contempt case number 5190/2022 has been filed. There are counsel representing respondent 1. There's no objections. Considering the fact that it is stated before the court that the directions contained in the order dated so and so, passed in WPC so and so has not been complied with. This court is of the view that the prayer made for implement of the incumbents in case of respondent one permitted to be arraigned. Stop. Accordingly, I stands allowed. Sri so and so, what is his name? This is the name of the person?
Ranjit Patwari, madam.
Sri so and so
No,
is arraigned as.
the new incumbent name is madam Chinmoy Prakash.
Huh?
Chinmoy Prakash Phukan, SCS.
Sri Chinmoy Prakash Phukan. Sailubai is arraigned as respondent number 2 in the accompanying contempt case number so and so. I accordingly stands disposed of. In the contempt case, you write, in view of the order passed today, the petitioner is permitted to file amended course title for the registry showing Sri Chinmoy so and so as respondent number 2. Matter be listed after 2 weeks thereafter.
Deeply obliged.
Much obliged.
42.
Please, your lordship. Lordship, here the IA is for the condonation of delay, lordship, and the miscase is for the restoration, lordship. Lordship, here the applicant has filed a writ petition bearing WPC number 1190/2020, lordship, for setting aside and passing the order dated 12/2/2018 passed by the Director of Account and Treasuries, the lordship. Lordship, in this matter, lordship, Learned Counsel, Bhubaneswar Kumar was engaged, lordship. But due to some miscommunication and unavoidable circumstances.
You have to first get the delay control.
Yes, lordship.
Why the delay?
I'm coming to the IA, lordship. The para 2 of the.
Any objections?
Yes, Your Lordship, we have objections regarding this. Your Lordship, Mr. R. Bobujari appears, he's on legs, Your Lordship, but we would like to file objections again. The IA, Your Lordship.
In the delay.
Yes, Your Lordship.
Okay. Third, counsel for parties issue notice. Returnable 3 weeks. MS
RM Barua, Your Lordship, for Mr. R. Bobujari.
RM Barua appears on behalf of the Finance Department, who submits that they would like to file their objections opposing prayer for condonation of delay. List again after 3 weeks, then the objection be filed in the meantime. Yes.
I've received the instructions, Manoj. Manoj, grant me 3 weeks time, I'll file the.
Mr.
B. Chaudhary.
B. Chaudhary, counsel for APDCL, submits that instructions have been received. He prays for 3 weeks' time. To bring it on record by way of an affidavit. Stop prayer made is not objected to by the counsel of the petitioner. He'll stop.
Items 53 and 54.
These matters, the declaration was available. In the file.
Yes.
So it came to our notice later, therefore we thought we'll complete it. Third, counsel for the parties. In deference to the earlier order dated 15/10/2025, whereby Justice Abhay Manohar Sapre, former judge of the Supreme Court of India, was appointed as the sole arbitrator. Was appointed as a prospective sole arbitrator to decide and dispute the differences arising between the parties out of the agreement, in the agreement itself. Justice Sapre has filed the written declaration as required under the provisions of the Act 2016, expressing no difficulty or handicap in conducting the arbitration as a sole arbitrator if appointed. So, in view of the written declaration received, which is placed in the case recorder of the registry, the appointment of Justice Sapre as the sole arbitrator is hereby confirmed. So, the parties will appear before the learned arbitrator appointed on
My lord, the date was, my lord, already.
17/11 we appeared.
17/11 we have appeared, my lord, already.
then.
Our next date, my lord. Next date fixed.
Next date not fixed.
Yeah, it's been fixed, my lord, but I'm not aware.
Huh?
It's been fixed, my lord.
Which one?
My lord, but I'm not, I have to confirm, my lord, this never the next date, my lord. I will just give him the date, my lord. Next date, my lord.
None of you have the dates?
No, my lord.
Huh?
No.
Will appear, you appear by 19th, 12th December?
My lord, my lord.
12th December for the arbitrator appointed. If no other date is fixed
My lord.
prior to that
My lord.
by the learned arbitrator. The arbitration petition accordingly stands disposed of in terms of the above. Both the petitions.
Both petitions, same.
The petitioners are disposed of. 53, 54. Contract numbers will have beleg, everything else is same. Yes.
55.
Kindly peruse the order dated 12/11/25. You are supposed to take instruction, my lord.
Yes, any instructions?
Instruction not received, Lordship, that instruction,
Not received.
not received, Lordship.
Government Council renews their prayer for further time to complete instructions. List again after 2 weeks.
No date may be fixed, my lord.
12th
Yes.
December.
Prepare for respondent number 4.
MS J. Chetri appears for respondent 4.
I am for 1, 2, and 3.
MS as for respondents 1.
On hearing item 56.
What was
Lordship,
this?
that translated version of the record is in the file, Lordship, that Lordship had, as the records are inquiry report, etc. in Hindi, so Lordship directed to replace it before the court, and registry had already translated it, Lordship.
This is termination.
Yes, Lordship.
Right. The matter is fixed for hearing and represents the writ petitioner. Since this is a matter for termination of challenging the termination of service, let this matter be listed again on January.
Lordship.